get started with their Friday afternoon, we'll get rolling. Okay. I think just about everyone knows me. For anybody who doesn't, my name is Peter Haven, and I'm the office attorney. And if you have questions about your real property transactions and you want to talk about anything or talk through an issue, feel free to give me a call, send me an email or a text. Just about everybody I think knows how to reach me. My email address is peter@havenlaw.com, peter@havenlaw.com. What I wanted to talk with you about today is dispute resolution, or disputes that arise in your real estate transaction. And this is largely what I deal with on a day-to-day basis when agents call me. There's a problem, there's a dispute, there's a conflict, somebody's upset about something, somebody is threatening something. And the first bit of advice that I would give to all of you about these disputes is try as much as possible to realize the big picture in all these disputes. And what I would tell you is that from my experience, almost 90 to 95% of the disputes that arise on transactions, in my opinion, are relatively small disputes. Now, why do I say that? Typically, a real estate transaction that we're dealing with is usually around $1 million sale, if not more. And most of these disputes involve dollar values that generously would be between $5,000 and $10,000. Most of them are less than that. And I would say that more than half of them involve disputes that are less than $1,000. And even though in the middle of these transactions, emotions can run hot and heavy, people can be very, very upset, and it can seem like a big deal, I would encourage everyone, when these disputes arise, to take a step back and just realize the magnitude of this so-called dispute relative to the entire transaction. As real estate agents, our primary bread and butter is getting into a sale contract and getting it closed. And the hardest part is usually getting into an accepted offer situation. And I would even go so far as to say that's about 90% of the work that needs to be done. The rest of it is massaging and pushing and negotiating over a few details. But really, the biggest job has already taken place if we're in an escrow transaction. And that's usually what I call the $1 million deal. Everything else is, in my opinion, relatively minor. So whenever you find yourself saying things like, but it's the principal, or they said they would do it, or I'm so tired of dealing with the agent on the other side, I would really encourage everyone to take a step back and remind themselves of where this dispute is relative to the transaction as a whole, relative to the total dollar amount of the dispute. And by the way, if anybody is out there, you might want to put yourself on mute just so we can minimize the background noise, etc. The other thing to keep in mind is that the vast majority of disputes that arise on real estate transactions are between the buyer and the seller. So, and real estate agents and brokers, we're not parties to the purchase agreement. I know we believe we are. You'll all have to forgive me. I am dog sitting today, and I've got a frustrated dog out here, and she wants to go outside. I've taken her out 3 times already. So I pardon me for that. The phrase "who let the dogs out" is appropriate. So these disputes are between buyers and sellers, and there's only so much that we can do to resolve these disputes. We don't have the authority to make the buyer and the seller agree on anything in particular. All we can do is make suggestions and try to get the parties closer together on resolving whatever dispute arises. We can't make them agree. Now, what are some examples of these disputes? You know, typically what I see in real estate transactions, and I'm going to draw a distinction today between disputes that arise during the escrow process, which I would refer to as pre-close of escrow disputes. And then we'll also talk a little bit about post-close of escrow disputes. And those are the disputes that typically involve the mediation and arbitration provisions in the agreement. The pre-close of escrow disputes are usually relatively small, they're negotiable, and they don't usually directly involve the mediation and arbitration provisions. Those usually come into play after the sale closes. But examples of pre-close of escrow disputes that I see, people will say, oh, you know, the seller promised to deliver the property vacant. They promised that there wouldn't be a tenant in there. And we get close to the close of escrow, and it looks for all the world like the tenant is still going to be there. Other times the seller will say, I promised, and there's a contractual provision in the agreement that says, I promised to fix something. And someone says, well, you didn't fix it very well. It doesn't look very good to me. I don't like the fix. Or there's a dispute of who's supposed to pay for something. There's a $1,000 or $2,000 or $3,000 termite recommendation, and it's unclear who's supposed to pay. So now there's a $1,000 or $2,000 or $3,000 dispute over who's supposed to pay for that. And even though these disputes can sound like they're very large in magnitude, they're usually very small in magnitude relative to the overall purchase price. And almost all of these disputes, almost all of these types of pre-close of escrow disputes, they can be resolved through simple negotiation. And it almost always comes down to a price credit. The seller had an agreement that the tenant would be vacated, but the tenant's not vacating. So how much do we have to reduce the purchase price to sell this property? And I know people will say, oh, the buyer swore up and down on a stack of Bibles that they would never buy this property with a tenant. They've made that absolutely adamantly clear. And I would tell you, as another tool of dealing with the dispute, is try not to become too much of a prisoner to what people say. I think it's important that you listen to what people are saying, but don't assume that just because they say something that they're giving you the 100% gospel truth. Lots of people take it as a negotiating posture that I'm not going to buy it, and I want that very clear, and I'm going to say that. Whenever somebody makes a statement to me like that, I tend to ask myself, I wonder how much of that is 100% correct. I wonder if that's honest to goodness their position. To state that a little bit differently, let's say you had $1 million home sale and you had a tenant who was supposed to be vacating, but they're not vacating. I view that as a price negotiation issue. And the buyer says, I will never buy this property under any circumstance if there's a tenant in it. Well, what if we took $10,000 off the sale price? No. What if we took $20,000 off the sale price? No. What if we took $30,000 off the sale price? Well, now it's getting to the point where it's pretty hard for the buyer to turn that down. So I believe that regardless of what people say, these disputes that arise before the close of escrow, they're basically disclosure and negotiation issues. You just have to disclose it, and then you have to negotiate what will happen because of this new material fact. The tenant's not leaving, the repairs are questionable, there's something else with the property that wasn't done the way it was agreed upon, or there's some dispute. My philosophy is disclose it, negotiate it, and figure out if there's an acceptable modified purchase price that will allow the sale to close. Now, real estate agents often get really hung up on these issues. And, you know, I commend you for being zealous advocates for your clients and for trying to do that. But understand that in the overall scheme of things, relative to the purchase price, most of these disputes aren't very high dollar volume amounts, and they really don't affect your commission that much because you're getting a percentage of the overall sale price. And these slight changes in potential sale price don't really affect your bottom line very much at the end of the day. And I would certainly encourage you not to let them get in the way of a sale closing. Now, what happens if the buyer and the seller simply can't come to an agreement and there's no amount of purchase price that's going to allow this sale to go through, even with whatever dispute or material fact has now been freshly disclosed? Well, cancel and walk away. If a seller is willing to cancel, if a buyer is willing to cancel and move on, that will oftentimes cause one or both parties to really truly assess whether they're willing to let the transaction go, disappear, or cancel and move on. And maybe it cancels, maybe everybody moves on, or maybe somebody gets really serious and they say, okay, let's see if we can work this out. But if it cancels, it cancels. It's not the end of the world. If you're representing a buyer, go find the buyer another property. If you're representing the seller, try to take the view, in my opinion, that canceling, if this buyer is that adamant about not purchasing on these terms with these disclosures and these last minute issues, then fine, let's cancel this deal and let's address these issues. And then let's put the property back on the market and find another buyer. Maybe we'll even increase the purchase price or the sale price because we've now addressed whatever these disclosure issues are. My suggestion to people is you allow the parties what I call their gravity. The buyer and the seller each want something. The seller wants the sale, the buyer wants the purchase. That's what I call their gravitational attraction. That's what keeps them coming together. And there's a price with all facts that will allow them to reach a deal. And if it's not going to happen, then it's not going to happen. And it's better to let them walk away and address the issue separately. Buyer can go find another property, seller can address the issue. Maybe the buyer even comes back after 3 or 4 months looking and they say, you know what, have you sold the property yet? Have you fixed that issue? Blah, blah, blah. Now I'm interested again. Okay. So don't try to micromanage these issues. Don't try to force the sale. Much of your job as a real estate agent after getting into the contract is simply making sure that your buyer and your seller are advised of all material facts, even if they're different than what are stated in the contract. Now, let's assume that one of these transactions that we talked about, instead of reaching an acceptable price point to allow the sale to go forward, instead, the buyer and the seller got bogged down in a real dispute over this, and the buyer says, I'm canceling, and the seller says, which is not uncommon, well, you can cancel, but you already removed all contingencies, and I want your deposit now. And the buyer says, well, you disclosed a new material fact, which allowed me to cancel, and I want my money back. So now you have a buyer and seller dispute, and the deposit is staying in escrow until that dispute is resolved. So let's take a look at the mediation and arbitration provisions in the contract. And I'm just going to draw your attention here. And I hope everyone can see that. Let's see if I move everything here. Okay. So the mediation provision, if the parties are in a fight, typically the buyer may issue a cancellation, and the buyer will check the box that says, I want my deposit back. And the seller may in turn issue a cancellation, and the seller's cancellation may say, I get to keep your deposit. And now the buyer and the seller have a dispute over what happens to the deposit. Typically, escrow will not release the deposit until both parties sign mutual instructions to release the deposit. That's usually the protocol. So now the deposit sits in escrow, and they've got to go to mediation to sort it out. Now, one question that I frequently get, if there's a dispute like this over a deposit, this important thing, one thing to keep in mind. The buyer and the seller have each signed a cancellation in the hypothetical I've given you, but the cancellations are not mutual. The seller says, I'm canceling and I want the deposit, and the buyer says, I'm canceling and I want the deposit. So it's not a completely effective cancellation of escrow yet, because they're not in mutual agreement over the terms of the cancellation. So one question that I frequently get is, can the seller go sell to someone else? And the answer to that question is yes, the seller can go sell to someone else. They will, in all likelihood, have to use a separate escrow. They cannot use the same escrow, because the escrow that has been the holder of this prior transaction that we're talking about, that escrow now has a non-mutual cancellation, so it doesn't have a complete and effective cancellation. And that escrow holder cannot have two so-called open escrows on the same property. They can only have one escrow at a time on one property at a time, unless there's a mutual cancellation. So a seller can go to another escrow and sell to another buyer, but the standard of care requires that that second contract to sell to a second buyer be subject to what we call the backup offer addendum or similar language, which basically says this sale to you is essentially a backup sale, and either party can cancel this agreement if they don't receive a mutually signed cancellation of the first deal. And someone says, well, what happens if there is no mutual cancellation? And as real estate agents, you can simply tell people, well, look, as far as I'm concerned, whoever buys it and whoever closes escrow owns it. But because we don't have a mutual cancellation on the first deal, I'm obligated to disclose that fact to you and give you this backup contingency, which neither party ever has to exercise. And as long as it closes escrow, it closes escrow. All right, now, what do you do about the deposit dispute that's still lingering on the first deal? Well, the typical RPA, this has always been in the RPAs, and it's in the most recent revised version. And I'm pulling up the, I've done a share screen with the purchase agreement here, so hopefully everyone can see it. And I'm highlighting the mediation provision, and the mediation provision is found in paragraph 30A. And one of the questions we often get is, what's the difference between mediation and arbitration? Well, when I think of the term mediation, I think of the term in statistics, which is referred to as the median. And the median is sort of considered to be the halfway point between two positions. And so you can think of mediation as an attempt to try to get to a middle point or middle ground. It's an attempt to try to settle and compromise a claim. Mediation as a word may sound a little intimidating, but I'm telling you, mediation, frankly, is a walk in the park. It's easy, it's relatively painless, and it is an attempt to try to mediate or find a middle ground that will allow the parties to reach a settlement. And remember, who are the parties? In the RPA, the parties are the buyer and the seller. So it is built into the purchase agreement in paragraph 30A, and it does not require being initialed. It is built into the RPA that the parties agree to mediate any dispute or claim between them arising out of this agreement or any resulting transaction before resorting to arbitration or court action. And it says the mediation shall be conducted through the Carr Real Estate Mediation Center, and it gives you a web page link there. or through any other mediation provider or service mutually agreeable to the parties. So they have agreed in advance that they're going to go to mediation, and they have agreed in advance that they'll use consumermediation.org, or they can come to another agreement to use another mediation service. As real estate agents, it's usually better for us to say, well, we're not experts in mediation. We recommend you use www.consumermediation.org, and you initiate the mediation process that way. Now, some of you may have gone through that process. Technically speaking, that is a process that the buyer and the seller are required to do. As you all know, buyers and sellers will try to get you to do everything for them, and you will do everything they want you to do until you push back a little bit. And I defer to each one of you as to when and where you want to draw those lines. But there's nothing that prevents the buyer or seller from clicking on www.consumermediation.org, and it's got an intake screen, and the person who's requesting mediation goes to that page and they start the mediation selection process. And I would encourage you to encourage your buyer and seller to do that, because putting them through that process is part of what begins to get them to think about resolving it. It's amazing how people get hung up on just going to a web page and saying, oh, I can't deal with this. I've got to click on buttons and type in names, and I just can't deal with it. Well, then maybe you should settle it. I defer to each one of you in that regard, but I think it's best if the buyer and the seller have to understand early on that's their process. And you should also know, and they should also know, that once you go to this consumermediation.org link and you start the process, at some point, if you're the buyer or the seller requesting mediation, the service is going to ask you to pay a fee. And it's an administrative fee. And I believe that right now that administrative fee is $400, I think, and it's non-refundable. So right off the bat, the buyer or the seller who is going to fight, in this example, about a deposit dispute, they're going to be asked to pay a $400 fee, which is another reason, by the way, that you can tell them they have to do it, because they're the ones who have to put down their credit card and pay that $400 fee. And that's the first step in driving people towards resolution, because people start immediately saying, you mean I have to pay for this? And, the general rule is that these types of battles should only be fought if parties are really, truly willing to pay to fight them. And if they're not worth paying money to fight about, that's part of the process that drives people towards a resolution. Okay. Now, it says here the parties, and remember, the parties means the buyer and the seller, because we're not parties to the purchase agreement. The parties also agreed to mediate any disputes or claims with agents who, in writing, agree to such mediation prior to or within a reasonable time after the dispute or claim is presented to the agent. What this means is, this next sentence says, mediation fees, if any, shall be divided equally among the parties involved, etc. So, generally speaking, the buyer and the seller are supposed to pay the mediation fees, and they shall be equally divided. Frequently, in these situations, the buyer or seller will say to you, I want you to come with me to mediation. You're the agent. You know the forms, you know the transaction, you know what happened. You're sort of an expert on the chronology and all of that. And so when your buyer or seller says, I want you to go with me to mediation, our advice is almost always, yes, I'm happy to go with you to mediation. I'm happy to participate in that process with you, but the mediation is between you and the other party, the buyer and the seller, and we cannot pay the fees for it. We're not paying the fees for the mediation. I'll agree to go with you and sit with you in the mediation, but we're not paying the fees for the mediation. That's the general rule. Now, there may be some instances where our client or principal or buyer or seller says to us, well, it's your fault, so I want you to pay the fees. And your response to that is, well, I need to discuss that with my broker. Now, and that's when, you call me up and we talk about it. But out of the gate, we do what the contract says, which is it's a mediation between the buyer and the seller, and they have to pay the mediation fees. We're not paying the mediation fees. The mediation fees are not very significant, but it's important to establish up front that this is a mediation with the buyer and the seller, and we're not paying anything for it, even though we're happy to appear with our client at the mediation. And it also telegraphs to them that we're not planning on paying any money to try to settle this thing as well. Now, what does showing up at the mediation mean? These days, post-COVID, in my experience, almost all mediations are done remotely via Zoom, the exact same technology that we're using now. And I find this method of conducting mediations to be outstanding, and I think it's going to become the way all mediations are conducted. And since the pandemic, I have not in any case participated in an actual on-site mediation, which is the way we used to do it before the pandemic. We always went to an office, we always showed up. We were on one side and the other parties were on the other side. We barely ever saw each other, but we showed up in person. All that's gone now, at least for the most part, and people do it by Zoom now. And it's a perfectly great way for you and for your client to participate in mediation. And what they do in mediation in a situation like this is they have what are called breakout rooms. So the mediator sets up a platform and everybody checks in, and there's usually an administrator who says, which side are you with? And the person says, I'm the seller, I'm the buyer, I'm Smith, I'm Jones. And then they immediately send you to a breakout room, and you never see the other party usually. So you go into a Zoom breakout room or a similar technology platform, and then you as the agent check in, and the same person says, which side are you with? And you say, I'm the agent for the seller or the buyer. And the person goes, okay, I'll put you in their breakout room. And then you go into a separate breakout room with your client. You don't have to physically be in the same space. You just need to be in front of your computer or laptop or device or whatever it is. And you guys are free to talk all you want, all you want. And the mediator will eventually come in and they will introduce themselves. Hello, I'm so-and-so. And they'll give you some song and dance about how mediation works. They'll tell you that everything is confidential. And they'll tell you that what you say here today is intended to help settlement, and let the mediator do his job or her job. Now, it's very valuable at these mediations to be able to show the mediator documents. So you use a feature like share screen, and you say things like, well, here, let me show you this document. They removed their contingencies on X date. And as you can see from this email, which was a week before, they knew all about these issues. We disclosed these issues. Here's the email dated a week before, and you can show these to the mediator on the screen, and you can email them to the mediator if the mediator requests. Why don't you email those to me? And then the mediator goes back to the other room and he talks to, in this example that I'm describing, he talks to the seller and he says, look, seller, these are their points, or actually let's do this the other way around. Let's reverse it. The seller would have presented that information to the mediator, and then the mediator goes to the buyer's room and says, look, buyer, they sent me your contingency removal, and they also sent me this email, and it says, it shows that you clearly had notice of these issues a week before you sent in the contingency removal. And, so they think they're entitled to their deposit, blah, blah, blah. And back and forth it goes. And, in an ideal world, the buyer and the seller would each have their respective agents in their respective breakout rooms. And then the agents and the principals can talk to each other and share whatever information that they have, and they go back and forth. These days, most of these Zoom mediations, especially ones conducted through carconsumermediation.org, they're usually about a half day, scheduled for about 4 hours. And especially if they involve something like a deposit dispute, usually 4 hours is enough. But if it's not enough, the mediator will say, well, we're making progress. Let's keep going. Another hour, another 2 hours. And then the mediator usually has a fee, and the parties get a bill after the fact regarding the fee. And so this is the way the process works. And I find it to be relatively harmless, relatively easygoing. Nobody has to settle if they don't want to. Mediation is non-binding. It's usually very informative and very helpful. And I take the view that there's really no such thing as an unsuccessful mediation, in my opinion. Almost every mediation is productive, even if it doesn't result in a settlement. Progress is made. The mediator is usually able to get the parties to move closer together. In the example that I'm talking about, we're talking about a deposit dispute. So let's just call it, keeping with the theme of $1 million purchase, let's just call it a $30,000 deposit dispute. So it's a $30,000 issue. And sellers will frequently say, what are we supposed to do at mediation? And the answer is, you're going to have to agree to negotiate that number. That's what the mediator is going to try to get you to do. And how far the parties move with their demands is a function of how strongly they feel about their respective positions. And you can see by this process that at some point, the buyer or the seller starts saying things to each other like, screw this, tell them we'll take half. Tell them we'll take a third. Tell them I only want 2/3. And that's the process. It begins the minute they start going through the respective hoops that they have to jump through to get to mediation. And that's usually the process that starts driving people towards a resolution. And that's why the whole process is important, not just showing up at the mediation. Now, I frequently see agents really take it personally, who gets the deposit on a particular failed or canceled real estate transaction. And I would tell you, why do you care who gets the deposit? It doesn't really benefit you in any way. You should all know that the listing agreement says that if the seller recovers damages as a result of this process, the seller, that you as the listing agent have a right to half of those damages. And the deposit dispute, for example, is liquidated damages. So in theory, the listing side is entitled to half of any liquidated damages recovery through mediation. I have almost never seen that 50% provision enforced. And even if you are, it's still not a lot of money, but it's certainly something worth considering if your seller, for example, is refusing to release a deposit to a buyer. And you might want to nudge your seller a little bit and say, look, seller, they have a reasonably decent reason for canceling, or they don't. And it's a $30,000 deposit, and I'm the listing agent, and I really want to get your property sold because that's how I get paid a commission. So it's not really, if we don't have this thing wrapped up, the next time we sell to somebody, I've got to give them a backup offer addendum. And, sometimes buyers get frightened or frustrated by that. They don't know what it means. So, we can definitely sell to someone else, but it's a little bit cleaner not to have to worry about that. And as a final thing for you to consider, my broker has the right to request half of whatever you recover. So if you go to mediation to fight about a deposit dispute, the mediator is just going to try to get you to reduce the amount of your demand. Let's say you you agree to take 15,000 and split it. In theory, my broker, I am entitled to half of that. And, you know, I'm just telling you, if you wanted to waive the whole deposit dispute and move on, that might be a better use of your time and resources. But whatever you want to do, Mr. Seller or Ms. Seller, I defer to each one of you if you want to raise that issue. In my experience, listing agents never enforce that 50% provision. They never raise it. And I'm not telling you that you have to raise it. I'm just telling you that you have it. And you can decide if you ever want to play that card at any time to remind the seller that you actually have an entitlement to a portion of these proceeds if the seller really wants to enforce that. Now, to flip it over a little bit, and keeping with the theme of a deposit dispute, I frequently hear buyer's agents say, you know, this is really terrible. You know, my buyer didn't do anything wrong and the seller is just a jerk. And we can't buy another property because we need that deposit. And it's really unconscionable what's going on. And, you know, I'm truly sorry about that. That may be true, but there's almost nothing that we can do about that except from the buyer's side, force the mediation process. You know, start the mediation process. If a buyer really needs to get their deposit back and it's being held hostage by a really irrational, malicious seller, which happens sometimes, there are crazy sellers out there, just like there are crazy buyers, then don't just spend time talking about, you better give it back, you're really bad, you're mean. Get going with the mediation process. Start to get some leverage. Start to put some deadlines on things. And the buyer will say, why should I have to pay $400 out of my own pocket? And my response to that, which, you know, I would offer to you to share with your buyer, is because if you don't, he's just going to let it sit there forever and we need it back now. We have to push the ball up the field. You know, in litigation, we often say attack, attack, attack. You know, if you don't press the issue, nothing's going to happen. All right. Now, there are some exclusions from the mediation agreement that are written into the contract. Some exclusions from mediation and arbitration include, the most common one is small claims. So let's say that this dispute that I've been talking about, instead of a deposit dispute, let's say that before the close of escrow, there was a $5,000 issue that manifested. It was a repair or a payment, say termite payment that the seller was supposed to pay. The seller didn't pay it. The seller was supposed to make a repair. The seller didn't make it. And let's say the buyer has gotten an estimate that this repair or whatever this item was, if it had been properly done pursuant to the contract, it's a $5,000 issue. The jurisdiction of small claims is $10,000. And so if the buyer wanted, the buyer could complete the sale, close escrow, and then take the seller to small claims court after the fact. And they could duke it out in small claims court because the matter is $10,000 or less, which is the jurisdiction of small claims. I would tell you as a buyer that if representing a buyer, if your buyer is going to go that route, I would strongly encourage you or your buyer to send an instruction to escrow that says, we're going to close escrow, but the seller violated this provision of the contract, and we're instructing escrow to keep and withhold $5,000, which is the estimated cost of what we now have to do, which is what the seller was supposed to do. And we request that escrow hold that after the close and not disperse it to the seller until we get a resolution or an agreement. Keeping the money in escrow, even after the close of escrow, is very valuable because you have this little chunk of change that's being held hostage. In my experience, escrows will usually comply with that request. They don't like it, but they will usually comply with that request. It doesn't have to be a mutually agreed upon request. It just has to be a unilateral request on behalf of the buyer. And most sellers will proceed to the close because the amount that's being fought over is small. And the reason why you want to do this is because once the sale closes and the seller gets all the money, we don't know where the seller's going to go. We don't know where they're going to be. They could leave the state. And, having money in someone's pocket is much harder to get out of them than having money in a neutral fiduciary third party holder such as escrow. So it's a suggestion. And, I would advise it to any buyer's agent representing a buyer where the buyer's going to close and they're going to try to ask escrow to hold back a certain amount of money pending, further dispute resolution. And they can go to mediation if they want. They can go to small claims if they want. That's really their choice, not yours. Now, one thing to keep in mind is there's an attorney's fees provision in the contract, and the attorney's fees provision says that in any action proceeding or arbitration arising out of this agreement, the prevailing buyer or seller shall be entitled to recover reasonable attorney's fees from the non-prevailing buyer or seller, except as provided in paragraph 30A, and 30A is mediation. And the mediation provision says, if for any dispute to which this paragraph applies, any party commences an action without first attempting to resolve the matter through mediation, or before commencement of an action refuses to mediate after a party has received a request for mediation, then that party shall not be entitled to recover attorney's fees, even if they would otherwise be available to that party in the action. In my opinion, that's a very important provision. That is why when your client says, well, why should I go to mediation? It's just a waste of time. My response is, well, you expressly agreed in a contract to go to mediation. As a real estate agent or broker, my general advice to you is do what you agreed to do in the contract. And third, if you refuse to mediate or you refuse to demand mediation, you could forfeit your right to recover attorney's fees, and that could be pretty significant bargaining chip if the action goes on and continues. So my attitude is, if a buyer or seller is talking about mediation, I advise the agent to say, you have to go to mediation. Whether you like it or not, you have to go, because that's what the contract says. And if you don't go to mediation, you're going against my advice to you. If they don't want to do it after we've advised them to do it, you can lead a horse to water. You do not have to make them drink. But one of my focuses is trying to minimize the likelihood that the buyer or seller points the finger at us and says, you never told me about that, blah, blah, blah. Now, we're not responsible for reading the contract and interpreting it for them. But the takeaway is, if ever there's a dispute and they can't resolve it and it can't be negotiated out before or after the close of escrow, tell your client to go to mediation. It's sound advice. It's consistent with the contract, and nobody can accuse you later of not saying that to them. And if they say, why should I go? You'll say, well, you have to go, read your contract, and my advice is go to mediation. Now, if the dispute is not resolved at mediation, and again, I take the view that all mediations are successful because progress is made, information is learned, people have to stop and go through the process. Mediation is a very powerful, positive force that we have to try to resolve these disputes. The contract says if it's not resolved at mediation, then the next step is arbitration. But this provision, the mediation provision, is built into the agreement. So as soon as they sign the last page of the agreement, they've agreed to mediation. Now, I've had some people say to me, my client doesn't want the mediation provision. He wants to counter, or she wants to counter it out of the agreement or just cross it out. And I tell agents, well, this is a contract between the buyer and the seller, and they can do whatever they want. I don't know if the other side is going to agree to it, but if they want to take out the mediation provision, they can. And if they say, well, why should I go to mediation? You say, look, in our experience, mediation is a productive and valuable process, and it's written into the contract. And, you know, it's our standard of care to say, we recommend you keep it in there. But hey, you know, if you know more than we do and you want to take it out, you go right ahead. You go right ahead. But our advice, don't mess with these contracts. Leave them the way they're written. But if they want to take it out, they can take it out. There's no guarantee the other side is going to agree. The same general rule applies with respect to arbitration. Now, arbitration, you know, this is something that we probably hear a lot of in the world today. Everybody, I think, was witness to whatever you want to call that trial was between Johnny Depp and Amber Heard. That was in a public court, and it was open to the public, and we all got to hear about it day and night for however long we wanted to hear about it, whether we wanted to hear about it or not. That's a public court trial. Arbitration is when the parties agree that instead of going to a public court trial, they're going to hire a neutral third-party mediator. And the mediator is a lot like, a neutral third-party arbitrator. And the arbitrator is a lot like the mediator, except the mediator wasn't trying to resolve the case by judgment or award. He or she was just trying to get the parties to come to some middle ground to reach a settlement, and the mediation was non-binding. And again, mediation for me, walk in the park. Arbitration is trial. So when they go to arbitration, they agree on a private arbitrator who's usually a retired judge. There are many services that provide arbitrators, and eventually they have a hearing in front of the arbitrator, and the arbitrator issues a ruling, and the arbitrator says, here's the judgment, here's who wins, here's who loses, here's how much, and here's the attorney fee award to go along with it. And then that judgment, that award from the arbitrator can be reduced to an enforceable judgment in state court. Then they get to go out and enforce that judgment and try to collect on the judgment. The biggest difference between arbitration and a courtroom trial is when you're in arbitration, there's no jury. You just basically have the judge. It's the arbitrator, and there's no jury, and the arbitrator decides. Sometimes there's a panel of arbitrators, but usually there's just one. The second biggest difference is when we file a lawsuit in state court, we typically pay a filing fee up front. That filing fee can be $500 to $1,000 per party. And then you don't pay for the judge after that. If you have a motion or you want to bring some special request to the judge, you usually pay a nominal fee to have to the court for the administration of that, but you're not paying the hourly fees of the judge. You get a free judge. In arbitration, the parties equally have to pay the judge, who is the arbitrator who is a retired judge, and those fees can add up because that is essentially another attorney who's billing the parties for his or her time. And those arbitration fees these days, I mean, they can be about $1,000 an hour, anywhere from $500 to $1,000 an hour. So there's a sense at which the more you use the arbitrator, the more you have to pay the arbitrator. And if one party has a greater ability to pay an arbitrator than another, that can lead to some difficulties in arbitration. And the last and final sort of issue with arbitration is some people think that arbitrators, because they're being paid by both sides, that there's a tendency in arbitration to quote unquote split the difference. I actually do not believe that, but some people do. If someone says to you, well, why should I agree to arbitration? You can simply say, look, I'm not a lawyer, but as a real estate agent, it's my understanding that arbitration is usually quicker and more efficient than trial. And it is. When a lawsuit is filed in a public court, Superior Court of California, it can take years for that case to get to trial. If you go to a private arbitrator, you can usually get it to a trial before the arbitrator within 6 months. It can be a little bit more expensive in terms of paying the arbitrator, but that's relative, and it's very hard to say because you usually get it resolved much more quickly. But you don't have a jury trial, and you have to pay the arbitrator. And, you know, I'm just a real estate agent. I'm not a lawyer. It's written into the contract like this. It's generally our advice that you agree to arbitration, but it's up to you. If you don't want to agree to it, you don't have to. And it's not agreed upon unless both parties initial. Now, you may have some lawyers who say, I hate arbitration and I don't want to do it. And you say, hey, man, do whatever you want. It's not my agreement. I don't care. If some people ask you, I've given you a few buzzwords and things to tell them. And I'll also tell you something else. Even if the parties mutually agree to arbitration, they can also each mutually, both of them, they can mutually agree later on to waive the arbitration clause if that's what they want to do. But they both have to be in agreement. If they both initial it and one party decides later on he wants to get rid of it or she wants to get rid of it, and the other party says, nope, we're sticking with it, then they both initialed it, and the party who wants to enforce it usually wins, and they have to go to arbitration. All right. That's a whirlwind. I gave you a lot of blah, blah, blah and legalese. Pardon me for that. If there are any questions, why don't you let me know and I'll do my best to answer them. You can give them to me now, or you can shoot me an email or give me a call later on, whatever you prefer.
May I ask you now?
Please.
Your example of the $5,000 dispute at the very end, won't in the one party asks escrow to hold it back, won't the lender hold up funding or hold up closing?
In my experience, the lenders do not hold up closing over something like that. My general rule on escrow holdbacks is this. It should be in an amount that's $10,000 or less. It should be an amount that's reasonably identifiable. It's not just pulled out of the air. You know, we've got an estimate or there was an agreed upon price. And third, the buyer asking escrow to do that should be able to point to a specific contractual provision that says right there, that's what the seller breached. Now, in my experience, I've never seen a lender refuse to fund escrow on those facts, because the lender's like, well, you're buying the property, you're going to get title to the property, we're funding the loan.
Hey.
You're still.
Hi, how are you?
I'm good. How are you?
Good. How's everybody doing? It's good to hear that.
Just ran for a quick
Hello. Hello. I can hear you talking about. Okay. Thank you. Anyway, I've never seen a lender refuse to fund on those facts because, as far as they're concerned, they're still funding the loan. The buyer's still incurring the loan obligation, and this is strictly a small dispute between the buyer and the seller regarding disbursement of escrow funds after the close. So my short answer to your question is I've never seen that.
Thank you.
All right. Forgive me for talking too much. I know I'm sure I put a lot of people to sleep, but you know, a lot of experience with this, a lot of ins and outs and nuances. If you have further questions, you let me know.
I'm awake.
Yeah,
Peter,
good. I'm glad somebody.
Peter, this was great. Thank you. No, thank you. It was great.
Well, you got the benefit of a lot of experience with this, and I know that most of you as very successful real estate agents, you don't have a need or a desire to focus on these issues. I encourage you all to take the big picture approach. Get your people into a contract, get that sale closed, get it paid a commission to you, and don't worry so much about all the piddling little details that arise, and don't think that something bad that happens is a tragedy. It's just a fact. Disclose it, negotiate it, get it closed, get it moved on. But I do think it helps you with that approach to have an understanding of what the process is if the parties can't reach a resolution. And I think personally, after spending 30 years as a litigator, getting people in and out of settlement, I have learned I usually don't try to force my people to do anything. I give them the facts, give them the options, and I try to gently explain to them, this is what the road looks like. My recommendation is you don't go down that road, but if you want to, there's the path. And people will usually make a rational decision when you lay it out for them like that. And if they don't, they don't. And above all else, don't you guys take this stuff personally, because that just gets you deeper and deeper into trouble. Okay, 12:59. Anybody
Thank you.
else? I'm going to stop sharing the screen now. And if there are any final questions, you can hit me with them. Otherwise, I have to walk a dog. I'm sorry.
Thank you.
Thank you,
Yes,
Peter.